Um, Still breaking down the Union Handbook, but before we get into the Union Handbook, I do want to give a shout out to this one YouTube channel. I've been watching them. Their videos are great. If you're into nature videos like I am and ocean documentaries, this will be for you. This is called um, Oceanic Wonders 8K. They have some really great videos about the ocean and nature and stuff like that. I've been watching them heartily since their channel started. Um, they got some fascinating stuff on this channel. Also, if you go in to the sidebar here, you'll see a lot of recommendations if you're watching ocean videos of other ocean channels. Like here, you got Dream Soul, Calm Dreaming, Kitten Playhouse, 8K Dream Color, Oceanic Harmony Sounds. Um, then you got Scenic Relaxation. Then they also got one for New York where it says 100 hours of New York City snow walk, which I don't know why anybody would want to be walking in the snow because to me, I would rather be inside. Um, you also got Explore Nature Talk, Oceanic Discoveries, um, Peaceful Music. Also, they use a lot of music and relaxation sounds in this. Let's play it for just a second and you'll see what I'm talking about. Let's turn my volume up here. Make sure I got my volume all the way up. Um, See, the music that they play is so peaceful and relaxing that you can fall asleep to these type of sounds. But you get the idea, okay? Was that a few days ago? I did my first live stream on my Rusty the King channel talking about the jinn. If you don't know what the jinn is, in Muslim culture is a genie who can grant you wishes, but depending on how you want to use him, he could either be evil or good. Um, so we got that. Now we're going to talk about the Union Handbook. Last week we left off at 31. We're picking up at 32. Um, okay, so here we go. Article 32, subcontracting. The employer agrees that no work or services of the the nature or type and including new operations or buildings covered by and presently performed are hereafter assigned to the collective bargaining unit shall be subcontracted, transferred, leased, assigned, or conveyed in a whole or in part to any other plant. Um, Person or non-unit employees unless otherwise provided in this agreement. Now, the employer may not subcontract work in any classification for the purpose of avoiding overtime. The employer may not subcontract work in any classification if any employee who normally performs such work is on layoff. Um, Now, prior to any subcontracting work, the employer will make all reasonable efforts to use the employees covered by this agreement. Um, Now, the number of car washer and porter jobs in the bargaining unit as of July 31st, 1990, shall be guaranteed from replacement by the employer subcontract in this work. Um, it is further agreed that additions to the workforce in areas that currently have bargaining unit employees performing this work shall become bargaining unit members covered under this agreement. Now, yes, and also the union handbook does have a cost of living section, which I'm going to get into right now, because certain areas are just high as hell when it comes to the cost of living, um, and a lot of times the pay raises that they give us are not adding up to what the cost of living is. Um, but if you're just tuning in, you guys can leave a comment. Let me know what you guys are thinking. And here like that, I do want to get to know the audience more. If you want to leave comments, let me know. Ask any questions that you feel free to ask. Um, Now, okay, Article 33 is the cost of living situation. All seniority employees who have completed their appropriate wage progression schedule shall be covered by by the provisions of a cost of living allowance as set forth in this agreement. Um, Employees who have not yet completed their appropriate wage progression on the effective date of the COLA increase shall receive the adjustment on a prospective basis on the date that they complete their wage progression schedule. Um, the amount of the cost of living allowance shall be determined as provided below on the basis of the consumer price index for the urban wage earners and clerical workers, CPIW revised series using 1982 to 1984 exponential patterns. All items 1982 to 1984 equals 100, published by the Bureau of Labor Statistics, the U.S. Department of Labor, and referred to herein as the index. Um, um, Effective on August 1st of 2024, um, on every August 1st thereafter during the life of the agreement, a cost of living allowance shall be calculated on the basis of the difference between the index for May 2024, published in June of 2024, and every May thereafter, and the base index for May 2023, published in June of 2023, and every May thereafter as follows. Yes, UPS does give a pay raise every August. Give it and then you won't see it right away, but you will see it like within the next couple weeks after you get it. I'm not sure what the raise is going to be. I get my first raise in August, so I don't know what it's going to look like. I don't know if it's going to be 50 cents, 75 cents, or $1. I guess I won't know until I see it. Now, for every 0.2 increase in the index over and above the base prior year's index plus 3%, there shall be a 1 cent increase in the hourly wage rates that are payable on August 1st of 2024 and every August thereafter. These increases shall be payable if they equal 5 cents in a year. All cost of living allowances paid under this agreement shall become and remain a fixed part of the base wage rate for all job classifications. A decline in the index shall not result in the reduction of classification base wage rates. Mileage paid employees shall receive a cost of living allowance on the basis of 25 cents per mile for each 1 cent increase in hourly wages, subject to the threshold set forth above. In the event that the appropriate index figure is not issued before the effective date of the cost of living adjustment, the cost of living adjustment that is required shall be made at the beginning of the first pay period after the receipt of the index. Now, in the event that the index shall be revised or discontinued, and in the event that the Bureau of Labor Statistics, the UPS Department of Labor, does not issue information which would enable the employer and the union to know what the index would have been had it not been revised or discontinued, then the employer and the union shall meet, negotiate, and agree upon an appropriate substitute for the index. Upon the failure of the parties to agree within 60 days thereafter, the issue of an appropriate substitute shall be submitted to the arbitrator for determination, and the arbitrator's decision shall be the final word and binding. Article 34, health, welfare, and pension. Section 34.1. Section 34, Article 1, full and part-time health and welfare insurance for employees. All full-time and part-time employees on the payroll as of January 1st of 2015 will be provided medical coverage through the Central States Health and Welfare Fund. Weekly payments for covered employees shall be in accordance with the rules set forth in the Central States Supplement. Now, UPS will be responsible for making the weekly payments to the Central States Health and Welfare Plan to provide the medical coverage in accordance with its agreement with the CS H&W plan. Now, individual and dependent spousal health coverage will be made available to part-time employees on the payroll who were hired after August 1st of 2018 after 9 months of active employment and upon ratification on a prospective basis only. Any eligible employee covered by this section who retires effective on January 1st of 2014 or thereafter shall be provided retiree medical benefits through the CS H&W fund. Section 34, Article 2, pension and health and welfare funding. Pension contributions for all full-time employees shall be $636.40 per week, with increases as specified in this section. Now the total health and welfare contribution for full-time employees will be increased on August 1st of 2023 and on each subsequent August 1st during the life of the contract as follows. August 1st of 2023, 50 cents, and then it keeps going until 2027, 50 cents for each one. The total pension contribution for full-time employees will increase on August 1st of 2023 as follows. August 1st of 2023, 30 cents. If in accordance with a duly adopted funding improvement plan or rehabilitation plan, The local Certified International Brotherhood of Teamsters pension plan is required to issue a schedule pursuant to a recess section 305 added by the Pension Protection Act of 2006. Um, that requires contributions in excess of those contained within the article. The union and the employer shall probably meet to negotiate changes in the agreement to generate sufficient savings to cover the cost of the increased contributions. Agreement shall not be unreasonably withheld, but once completed, the applicable fund shall be obligated to accept the schedule as if it was the beginning of the term of a new labor agreement. Um, Now, in the event that the local certified pension plan is unable to maintain its current zone status under the RESA Section 305 added by the Pension Protection Act of 2006, during the term of this agreement at existing contribution rates because of the limits described in C above, the parties agree to meet and discuss those circumstances and any ramifications on the provisions of this article. Now, Section 34, Article 3. The employer payments to the fund shall be as follows. The amount per employee per week shall be paid for each regular employee covered by this agreement for any week in which such employee performs any services for the employer, even when such services are not performed under the terms of this agreement. Payment shall be made on replacement for absentee employees for the days worked by such replacements at a rate equal to 20% per day of the aforesaid weekly payment. Now, if an employee is absent because of a non-occupational illness or injury, the employer shall pay the required payment for a period of up to 4 weeks. If an employee is absent because of occupational illness or injury, the employer shall pay the required amount for the period of 12 months. Now, the obligation to make the above payment shall continue during periods when a new collective bargaining agreement is being negotiated. Now, all leaves of absence, when granted by the employer in addition to the requirements of the parties, shall be conditioned upon the employer and the employee making satisfactory arrangements for paying the weekly payment to the fund, and at all times the payment shall be made by the employer for the period of such granted leave of absence. Now, the employer is not obligated to make payments to the fund for any absent employee, except as outlined in the subsection above. The contributions required to be paid hereunder shall be paid for all days of work, which are paid for under the holiday and vacation provisions of this agreement. Section 34, Article 4. Whenever the union is in its discretion determines that the employer is a delinquent in making payments to the pension trust fund as required under this agreement or the rules and regulations of the fund, and meetings shall be scheduled between the company and union co-chairs. If a resolution to the dispute cannot be reached, the union shall provide the company with a 72-hour notice prior to striking the employer to enforce any payment. Section 34, Article 5. Payments shall be made to the local certified International Brotherhood of Teamsters Pension Trust Fund, which is an irrevocable trust heretofore created by an agreement and declaration of trust pursuant to a collective bargaining cartridge agreement between employers and the union. The fund shall use these payments for purposes permitted under the trust agreement and to provide pension, death, and such other benefits as permitted by the said trust agreement as amended. Sections 34.6 full-time and full-time long-term disability, which they do have that. The long-term disability shall be provided for full-time employees during the term of this agreement as detailed in this section. Full-time seniority employees will become eligible for long-term disability after 6 months of employment for non-occupational illness or injuries that last longer than 26 weeks. Long-term disability benefits will equal 60% of the employee's base weekly pay to a maximum of $800 per week for up to 5 years. Long-term disability benefits begin when short-term disability coverage ends, or after the 26 weeks from the date of disability, whichever is later and whichever is greater. Average weekly base pay is computed by averaging paid hours, maximum of 40 hours per week, each week during the last calendar quarter the employee worked, and multiplying that by the hourly rate of their base job. Now, weeks of employment in the prior quarter will not be counted in the calculation, but if there were substantial weeks of employment, the prior full calendar quarter may be used for the calculation. Now, the definition of disability, termination of eligibility, offsets, the exclusions, limitations, claim procedures, and any other related issues will be confronted by the summary plan um, description. Now, the long-term disability coverage will become effective on January 1st of 2015 for the eligible employees who become disabled after that date. However, pre-existing conditions will not affect the employer's ability or eligibility for the LTD. Now, coverage provided by the prior contract shall remain in place through December 31st of 2014. Now, now an employee receiving LTD benefits pursuant to this plan shall be entitled to receive health care coverage from CSH&W for up to 12 months only. An employee will not be denied LTD benefits under this section based on failure to qualify for Social Security benefits. Um, Section 34, Article 7, UPS Part-Time Pension Plan. Now, the UPS pension plan shall be improved to provide monthly benefits to part-time employees as follows. The benefit formula in the UPS pension plan for current or future part-time employees who are participants shall be increased effectively on August 1st of 2004, which that already happened 21 years ago, to $55 for each year of past and future credited service to a maximum of 35 years of credited services. There are some people at UPS who've been there for 20, 30, 40 years, and they're still there. Um, the benefit formula in the UPS pension plan for current or future part-time employees who are participants shall be increased solely for purposes of the monthly accrued benefit, effective on August 1st of 2008 to $60 for each year of the future credited service to a maximum of 35 years of accredited service. Now, if a participant is in fact covered employment on August 1st of 2008, they shall receive the $60 benefit formula for the entire 2008 plan a year. Now, effective on August 1st, now this was effective on August 1st of 2023, which was about a little over a year ago. The benefit formula in the UPS pension plan for current or future employees will be increased to $65 for each year of future accredited service to a maximum of 35 years of credited service. Now, if a participant is in fact a covered employee on August 1st of 2023, they shall receive the $65 benefit formula for the entire 23 plan year. Now, the total monthly service pension benefit shall be equal to the following, provided that the employee meets the accredited service requirement. Now, $2,450 at any age after 35 years of accredited service, $2,100 at any age after 30 years of accredited service, $1,750 at age 60 with 25 years of accredited service, and $1,450 at any age with 25 years of accredited service, based on $58 per hour per year of credited services. Part-time employees shall receive 1 year of credited service for 750 or more paid hours. 6 months of part-time accredited service shall be granted for 375 to 500 hours worked in any calendar given year, and 9 months of part-time accredited service shall be granted for 501 to 749 hours worked in a calendar year. This paragraph shall also be applied to determine credited service for full-time employees on the payroll on August 1st of 2002 who were formerly participants in the UPS pension plan. The employer shall be responsible for funding the UPS pension plan as required to provide the benefits that are described in the above section. And they shall be responsible for maintaining this plan. The UPS pension plan shall be governed by the terms of the plan document. Now, this was effective on August 1st of 2002. The employer shall grant additional years of credited service in accordance with the terms of the plan to all full-time and part-time employees on the payroll on August 1st of 2002 who worked for UPS after they were 21 but were denied credited service solely because the UPS pension plan required that an employee be 25 years or older to participate in the UPS pension plan. Now, for those multi-employer pension plans with which the UPS pension plan does not have reciprocity, the UPS pension plan shall execute a mutually agreeable reciprocity plan agreement with those plans. Now, like I said, UPS does have a lot of great benefits once you put your time in. Um, I've only been there since September, so I'm coming up on like 5 or 6 months of working there, and the stuff is not bad. You get a lot of great benefits sticking out with them. Now the company will amend the UPS pension plan to allow an employee with an hour of service in the covered employment on or after August 1st of 2013 to become a participant on the January 1st or July 1st, whichever is earlier, after reaching age 21 and completing a 12-month period of employment beginning on the hire date. Any subsequent calendar year in which they were earned at least 375 hours of service. In addition, in order to receive any retroactive benefit service as a result of the change, the employee's primary job as of August 1st, 2013, must be a part-time position, which I do not agree with. The pension plan will also be amended to reduce the number of hours of service required to even invest in year form 750 to 375. This paragraph does not change how benefit service is accrued in any way. Um, Section 34, Article H, part-time retiree health and welfare coverage. The employer shall provide health insurance coverage to all part-time employees that are not covered by a union plan, and they retire on or before January 1st of 2014, as outlined in the UPS Health and Welfare Package Summary Plan description. Any eligible employee who retires effective on January 1st of 2014 or thereafter shall be provided retiree medical coverage through the CS-H&W Fund. Now, for active retirees as of December 31st of 2013, the contribution rates and benefits shall be specified in the summary plan description. Um, Now we're going into Article 35. I gotta get new glasses. My glasses are fucked up as it is. My glasses keep falling down. I gotta get them either adjusted or get some new ones. Um, Article 35, employees bail license substance and alcohol testing. UPS is very big on drug testing people. Um, when an employee is required, so Section 35, Article 1, employees bail and our court appearance. Now, when an employee is required to appear in any court for the purpose of testifying because of any accident that the employee may have been involved in during working hours, such employee shall be reimbursed in full by the employer for all earnings opportunities lost because of such appearance. Now, the employer shall furnish employees who are involved in accidents during working hours with bail bond and legal counsel and shall pay in full for the same. Employees shall be compensated for the time spent in jail at their regular rate of pay. Now, the said bail bond and legal counsel shall remain assigned to the employee until all legal action in connection with said accident is concluded and finished up, provided that the employer is not charged and convicted of any criminal negligence. Um, Now, this section shall not apply to employees who are found guilty of drunken driving when involved in an accident during working hours. The employer shall assume all responsibility for all court costs, legal fees, and bail bond fees for any employee who is involved in any accident or accidents during working hours, and shall assume all responsibility for all judgments and awards against any employee who is involved in accidents during working hours, which result through court action against said employee, except as provided above. In any case, an employee shall be subpoenaed as a witness to a company-related case, or as a result of their on-duty observations of an accident not involving a UPS vehicle. They shall be reimbursed for all time lost and expenses incurred. Um, Section 35, Article 2, suspension or revocation of a license. In the event that an employee shall suffer a suspension or revocation of the right to drive the employer's equipment for any reason, the employee must notify the employer before their next report to work. Failure to comply shall subject the employee to disciplinary action up to and including a discharge in accordance with the procedure set forth in this agreement. We already discussed Article 16 and the leave of absence, which was also discussed in Article 16, Section 3. Now, if such suspension or revocation comes as a result of the employee complying with the employer's instruction, which results in succession of size and weight penalties, or because the employer or the employee complies with the employer's instructions to drive employer's equipment, which is in violation of the Department of Transportation regulations relating to equipment, or because the employer's equipment did not have either a speedometer or tachometer in a proper working order, and if the employee has notified the employer of the citation for such violation as above mentioned. The employer shall provide employment to such employees and not less than the employer's regular earnings at the time of such suspension for the entire time period. Section 35, point 3, controlled substance testing. The parties have agreed that the procedure is set forth in Article 35, Section 3. It shall be the methodology for all testing and shall be modified only in the event that further federal legislation or Department of the Transportation regulations require the revised testing methodologies or requirements during the term of this agreement. Um, to the extent a subject is not covered by this article, the appropriate regulation shall control. Um, should other categories my knee is still is not too bad. It's still got the bruising on it. And then yesterday I took a fall. Um, slipped on some ice, and I scraped up my hand. So now I got my hand hurting a little bit too. It's with the weather out here. We got a lot of ice. We did have some snow. Um, yeah. So basically with the hand too, I was coming out of a restaurant, slipped on some ice, and scraped up my hand, and my hand was bleeding pretty badly. And now it's a motherfucker trying to walk on some ice. Um, now, should other categories, modifications, or types of testing be required by the government, the parties shall meet as expeditiously as possible to develop a mutually agreeable procedure. Um, the provisions of Article 16, Section 16.5 shall apply to all employees requesting enrollment in a rehabilitation program following a positive drug test. No, I did not go to a clinic, so I did not get workers' comp for that. I'm still working. Um, the provisions of Article 16, Section 16.5, like I was saying before, apply to all employees requesting enrollment in a rehabilitation program following a positive drug test. Now, employees may use the United Parcel Service Employee Assistance Program, a union-sponsored program, as well as any other referral service in choosing an approved program for treatment. Section 35, Article 3.1, employees who must be tested. UPS employees subject to the Department of Transportation mandated drug testing are drivers of vehicles with a vehicle weighing over 26,000 pounds. Requiring a commercial, you require a commercial driver's license, or also known as a CDL. I don't have a CDL. Don't plan on driving trucks. I'm not really big on that one. This includes mechanics this includes mechanics and employees who relieve for vacations or other temporary vacancies. Now, any employer or employee who drives a tractor trailer and is on the qualified feeder driver list is also subject to DOT mandated testing as provided in this agreement. In addition to testing, mandated employees controlled substance testing shall be part of pre-qualification conditions for feeder driver employment, and those persons referring to a feeder driver position. Individuals who are on a bid list for tractor trailer employment or other similar classification type jobs are subject to being tested. Yes, a long time ago. Haven't done it any for a while. Now, in addition to testing, mandated employees controlled substance testing shall be part of pre-qualification conditions for feeder driver position. The individuals who are on the bid list for tractor trailer employment or other similar classification type jobs are subject to being tested for a controlled substance before being accepted into such a position. Now, employees who are covered by this collective bargaining agreement who are not subject to the DOT mandated drug testing are only subject to reasonable cause testing as provided herein. The substances for which testing shall be conducted and cutoff levels thereto shall be consistent with those listed consistent with those listed for the DOT covered employees. This provision also applies to testing conducted pursuant to rehabilitation after the care programs. Now, Section 35, 3.2, testing. Because of the consequences that a positive test result has on an employee or any given employee, UPS shall employ a very accurate two-stage testing program. Urine samples shall be analyzed by a highly qualified independent laboratory which is certified by the Department of Health and Human Services, and all samples shall be tested according to the DOT drug testing requirements. The validity testing for the presence of adulterants shall be conducted on all specimens per the HHS requirement. Section 35, 3.3, screen testing. The initial test uses an immunoassay to determine levels of drugs or drug metabolites. The following initial cutoff levels shall be used on screening specimens to determine whether they are negative for at least 5 drugs or drug classes. Marijuana 50 50 cocaine 150, codeine or morphine 2000, or hydrocodone or hydromorphine 300, oxycodone or oxymorphine morphine 100, acetylmorphine 10, and phencyclidine 25, crystal meth 500, or MDMA 500. Um, those are the drugs that they mainly test for. Any of those drugs can cause you to be suspended or fired from the job. Um, to me, marijuana shouldn't even be a cause for being fired, but the other drugs can be. These substances and test levels are subject to change by the Department of Transportation as advances in technology for any other considerations of warrant. Section 35.4, Section 35, 3, Articles 3, 4. Confirmatory test. All specimens identified as positive on the initial test shall be confirmed using gas chromatography and mass spectrometry techniques at cutoff values listed. The following cutoff levels shall be used to confirm in the presence of drugs and drug metabolites. Yes, crystal meth is on the list. And I'm going to read it again because now we're going to go down to the next list for the substance. Marijuana, cocaine, codeine, morphine, hydrocodone, hydromorphine, oxycodone, oxymorphine, acetylmorphine, phencyclidine, crystal meth, MDMA or MDA. For group analytes, i.e., 2 or more analytes that are in the same drug class and have the same initial test cutoff immunoassay, the test must be calibrated with one analyte from the group that identified as the target analyte. The cross reactivity of the immunoassay to the immunoassay to the other analyte within the group must be 80% or greater. If not separate immunoassays must be used for the analytes within the group. A alternate technology, either one analyte or all analytes from the group, must be used for calibration, depending on the technology. At least one analyte within the group must have a concentration equal to or greater than the initial test cutoff. No. Well, I am in the union, and I have to, but if I want to study something and I want to get to know more, then I could read the book. You don't necessarily have to be in the union to have a book. Or actually, if you're a supervisor, you can't be in the union and cannot have a book. If you're an hourly employee, you're already in the union anyway after your 30 days, and I'm well past my 30 days. Now, alternate technology, either one analyte or all analytes from the group, because basically, once you become a supervisor, you lose all union benefits. You got to pay out of pocket for your own insurance. They're not allowed to attend meetings. They're not allowed to participate in anything that is union based. Don't ask me why that's even a role there, but none of the supervisors in UPS are. Not one supervisor in the UPS is considered in the union. Only the hourly employees. I do not want to be a supervisor. Don't want to be one because I do not want to lose my union benefits. Now, depending on the technology, at least one analyte within the group must have a concentration equal to or greater than the initial test cutoff, or greater than the laboratory's validated limit of quantifications. Must be equal to or greater than the initial test cutoff. Being a supervisor at UPS is not as all as it's cracked up to be. A lot of them are hard asses. A lot of them are racist. So I just don't want to deal with the supervisor role. I'm the type of person who does not like being talked down to. If you talk down to me, don't expect me to not hold my tongue because I will speak my fucking mind. Um, and if an immunoassay must be calibrated with the target analyte, a 9 tetra cannabino 1-9 carbo acid. I've never done acid before, so acid is also on this list. Wow. I've never done acid. Not to say that I don't want to try it, but um, alternate technology, THCA and benzo. When using an alternate technology, initial test for the specific target analytes of THCA um, and the benzo lecconine, the laboratory must use the same cutoff for the initial and confirmatory test. Um, we got crystal meth on here, which is also known as MDMA, and also and then those MDMA and MDA, they're both kind of like crystal meth. In the event that the initial drug test indicates a positive response, the confirmatory test must be done. On an initial drug test, the laboratory must report a result below the cutoff concentration as negative. But if the result is or above the cutoff concentration, the laboratory must conduct a confirmation test. On a confirmation drug test, the laboratory must report a result below the cutoff concentration as negative, and a result at or above the cutoff concentration as a confirmed positive. Last year, when I was working my old job, I had an injury that they drug tested me on. Um, my ring finger on my hand. Um, the ring finger on my right hand does not move at all. Um, so it stays like that. So if you see that, I'm trying to move. I'm trying to move the ring finger on my hand. It's not moving. See, it's barely moving at all. That was from an injury I had suffered last year at my old job. Um, I was working in the kitchen when a piece of glass shattered in my hand, severing off the ring finger. Um, like right here is where it severed off at. They had to actually sew the finger back on, and my finger was able to be saved. But the only problem is now I got no movement in it. Um, So that was an injury I had suffered last year, and surprisingly, I did not get workers' comp for that at all. But I missed 3 weeks of work for that injury. Um, it was a motherfucker. I'm telling you, that thing hurt like fucking hell. Um, now these substances and test levels are subject to change by the Department of Transportation as advances in technology and or any other considerations warrant. Um, Section 35 Section 35 Articles 3.5 laboratory testing. All laboratories selected by UPS for analyzing controlled substances testing participants shall be HHS certified. Um, Section 35, Article 3.6, types of testing required. Testing procedures shall be performed as part of a pre-qualified practice after defined reportable accidents on the basis of reasonable cause upon return to duty after a positive test under mandated random testing, and as follow-up testing for post-drug rehabilitation as outlined under Article 16, Section 16.5. Now, Section 35. Article 3.7, pre-qualification testing. Controlled substance testing shall be part of a UPS regulated pre-qualification condition for feeder driver positions. I've never wanted to be a truck driver. To me, that's just not my thing. Drivers shall be advised in writing prior to the application process that pre-qualification testing should be conducted to determine the presence of a controlled substance. Applicants shall be required to acknowledge in writing an understanding of this request before they receive an application. Section 35, Article 3.8, reasonable cause testing. Sometimes they do have reasonable cause if UPS suspects that you're high or drunk. They have a reasonable cause to test you. Upon reasonable cause, UPS shall require an employee to be tested for the use of controlled substances. Um, Reasonable cause is defined as an employee's observable action, appearance, or conduct that clearly indicate the need for a fitness for duty medical evaluation. Now, the employee's conduct must be witnessed by at least 2 supervisors if available, and the witnesses must have received training in observing a person's behavior to determine if a medical evaluation is required. When the supervisor confronts an employee, a union representative should be made available pursuant to Article 4 of this agreement. If no union steward is present, the employee may select another hourly paid employee to represent them. Documentation of the employee's conduct shall be prepared and signed by the witness within 24 hours of the observed behavior or before the test results are released, whichever is earlier. In addition, a copy shall be sent to the union within 48 hours. Now here's a note for any other reasonable cause. At the time the urine specimen is collected, the employee may also opt to give a blood sample if they choose to. If the employee takes this option, the blood sample must confirm a positive presence for the substance confirmed in the urine test. If no positive is confirmed in the blood specimen, the employee should be given a warning letter, offered an opportunity for rehabilitation as set forth in the article, and the employee shall be required to otherwise satisfy the requirements imposed by the DOT regulations. However, if there is a second occasion where reasonable cause testing results in a positive urine test, the employee shall then be subject to be fired. You also have a non-DOT reasonable cause. In the event an employee not covered by DOT is tested pursuant to the discipline article in this agreement, such tests shall be performed under the same procedure and requirements as those set forth in this article. In the event that the test result is positive as set forth above, it shall be considered a dischargeable offense. Section 35, Article 3.9. Post-accident drug testing. DOT-mandated drivers shall be required to submit to a drug test after a DOT-defined serious accident, which is one in which there is a fatality, or a citation is issued and there is bodily injury to a person who, as a result of the injury, receives immediate medical treatment right away from the scene of the accident, or a citation is issued and one or more motor vehicles incur disabling damage as a result of the accident, requiring a vehicle to be transported away from the scene by a tow truck or other vehicle. Non-DOT mandated drivers may be required to submit to drug testing if there is any reasonable suspicion of a drug usage or reasonable cause to believe that a driver has been operating the vehicle while under the influence of any drug or alcohol. Drivers are required to submit to such testing as soon as possible, but in all events within 32 hours. Union representation shall be made available pursuant to Article 4 of this agreement. It is not the intention of this language to prohibit the driver from leaving the scene of an accident for the period of time necessary to obtain assistance in responding to the accident or to receive necessary medical attention. The result of a urine test for the use of controlled substances conducted by federal, state, or local officials having independent authority for the test shall be considered to meet the requirements of post-accident testing, provided that such tests conform to applicable federal requirements and that the results of these tests are obtained by the employer. Now, Section 35, Article 310, Random Drug Testing. Random Employee Selection. The procedure used to randomly select employees, DOT-mandated employees only for drug testing, and compliance with the U.S. Department of Transportation regulations, shall be a computer program which is specifically intended for such an application. Now, the program shall utilize an internal computer clock procedure and to randomly generate list of employees mandated for testing by the Department of Transportation and Federal Highway Administration. The computer shall randomly select the required number of employees from the total pool of affected employees, and the total pool list shall be each region. For verification purposes and to cover absences, the computer shall print the following list for each testing period. An alphabetical total pool list of employees in the region. A district list of employees shall be printed from the random list in the order in which they are computer selected. An absent employee whose name appears on the primary list On the random test day must be tested upon return to work immediately upon notification, provided that their returns prior to the next selection period. The list or true copies of the list shall be maintained by a third-party administrator. Upon request to the District Labor Relations Manager, the list shall be made available for review by union representatives and company labor relations managers to verify the proper application and use of the list and the random testing system. The parties agree that no effort shall be made to cause the system and method of selection to be anything but a true random selection procedure, ensuring that all affected employees are treated fairly and equally. The parties further agree not to amend or change the current method of random selection as described herein without prior agreement between the parties. Section 35, Article 11, notification. UPS employees subject to Department of Transportation mandated random drug testing shall be notified of testing in person or by direct phone contact. Notification shall be given by the management person responsible for such notification. Section 35, Article 12, rehabilitation and drug testing after return to duty. Because UPS, even if you tested positive for drugs and you become clean, they want to make sure that you're staying clean after you get out of rehab and everything like that. They want to make sure that you're on the up and up. A positive test specimen as a result of a pre-qualification of random test shall result in rehabilitation opportunity. An employee whose test results are reported to the medical review officer by the HS certified laboratory and who has been contacted by the medical review officer MRO or their designee has 72 hours to contact the medical review officer to review the test results. If the review time schedule is not met, then the medical review officer may report to UPS management that the test is verified as positive. If neither UPS nor the medical review officer, after making all reasonable efforts as required by the DOT regulations, is able to contact the employee within 10 calendar days from receiving the laboratory results, the test shall be considered an uncontested positive test result. Now, if the medical review officer determines a specimen is positive, then the employee shall have 5 calendar days to evaluate their situation with a substance abuse professional, counselor, and then up to 15 calendar days to enter the Rehabilitation Treatment Center after approval of a leave of absence is outlined in Article 16 of this agreement. Now, UPS shall follow the final recommendations of the substance abuse professional, also known as the SAP, as to the appropriate aftercare protocol and post-rehabilitation unannounced drug testing. The employee shall be permitted to return to work after the SAP has determined that the employee has successfully complied with the prescribed education and/or treatment, and the employee has provided a negative drug test result. Conducted under direct observation as per cutoff levels obtained in Section 35.3 or Section 35.4 of this article as applicable, and or an alcohol test with an alcohol concentration less than 0.02. Usually, to be considered legally drunk, you got to be a 0.08 or higher. Now, the employer will make all reasonable efforts to conduct all return to work testing, conference calls, and examinations within 5 calendar working days of completion of a rehabilitation program. I've never actually had to go to drug counseling. I've never actually had to go to alcohol rehabilitation because I'm not a diehard drinker, or I'm not a diehard alcoholic, and I'm not a diehard drug user, so I don't have to worry about ever going to counseling unless it comes to that. It is understood that if the grievance procedure is utilized, contractual time limits, disciplinary actions, and the employee's request for rehabilitation shall be suspended until resolution of the grievance. Now, this book is good up until 2028. So by July 31st of 2028, they'll have a new union book out, and then I'll get that one too. Every time they do a new union book, they update them every 5 years. They updated this one in 2023, and this is good up until 2028 because you can see that on the year here. You can see on the thing here it says good from August 1st of 2023 until July 31st of 2028. So that's what this book is good for. Now, there's a note on the substance abuse professional, also known as the SAP. Each substance abuse professional, also known as an SAP, must be a licensed doctor of medicine or osteopathy, or a licensed or certified psychological social worker, employee assistance professional, or drug and alcohol counselor certified by the National Association of Alcohol and Drug Abuse Counselors Certification Commission. Um, and they have to have knowledge of and clinical experience in the diagnosis and treatment of alcohol and controlled substance related disorders, and they have to be knowledgeable of the SAP function as it relates to the employer interest and a safety sensitive function and an applicable DOT agency regulation. Now, in addition, the SAP shall keep current on applicable DOT agency regulations and comply with the DOT qualification training and continuing education requirements. Um, the SAP is responsible for performing the following functions: conducting the initial face-to-face clinical assessment and evaluation to determine what assistance will be needed by the employee to solve problems associated with alcohol or drug use. Um, referring, referring the employee to an appropriate education and or treatment program, conducting a face-to-face follow-up evaluation to determine if the employee has actively participated in the education and or treatment program and then they have demonstrated successful compliance with the initial assessment and evaluation recommendation, and providing the employer with a follow-up drug and or alcohol testing plan for the employee, and providing that the employee and the employer with recommendations for continuing education and or treatment. Now, follow-up testing shall consist of at least 6 tests in the final 12 months following the employee's return to duty. The 1-year period may be extended as necessary by written verification of the substance abuse professional. Tests shall be conducted under direct observation. The affected employee and local union shall be notified in writing within 10 days of any extension required by the SAP beyond the required 1-year follow-up testing period. Also, when I get done with the union book, I'm also going to possibly have what they call, if you go on UPS's website, they also have different news articles and different stories that you can read up on. After I get done with my union book, I might have that. Once I get done reading the union book, I'll give you some top stories on the UPS news site, where they talk about different things that they're investing in. That'll be a story for next week. Now, the employer responsibility. Prior to allowing an employee to return to duty after the employee has tested positive for the presence of controlled substances or has refused to submit a drug test, the employer shall ensure that the employee is drug-free based on a drug test that shows no positive evidence of the presence of a drug on a drug metabolite in the employee system. They have to ensure that the employee has been evaluated by the substance abuse professional for drug use or abuse. Ensure and confirm that with the substance abuse professional that the employee demonstrates the compliance with all conditions or requirements of a rehabilitation program in which they are participated in. Now, Section 35, Article 13, disciplinary action. You can be disciplined for drug abuse and everything else. Employees may be subject to discipline up to and including discharge as provided below if they test positive for any drug. And that's specified elsewhere in the article, which I already gave that breakdown. Reasonable cause testing. A positive test is a dischargeable offense unless the union and the employer expressly agree to a lesser penalty. Any such agreement should not be a precedent setting. Refusal to submit to a reasonable cause drug test is a dischargeable offense. Now, if you're a non-driver, because I don't drive any vehicles for UPS. The first offense, a positive test for cannabis marijuana, shall result in a warning letter, subject to successful completion of rehabilitation. The second offense, a positive test for cannabis marijuana 5 or more years after the first offense, shall result in a warning letter, subject to a successful completion of rehabilitation. A third offense, a positive test for cannabis marijuana, is a fireable offense. Post-accident testing. A positive test is a dischargeable offense. Refusal to submit to a post-accident drug test is a dischargeable offense. Random testing. The first offense, a positive test, shall result in a warning letter, subject to successful completion of rehabilitation. Second offense, a positive test is a dischargeable offense. Refusal to submit to a random drug test is a dischargeable offense. Now, pre-qualifications. A first offense, a positive test shall result in disqualification. That's not considered for feeder list until the next feeder driver school is conducted, subject to successful completion of rehabilitation. Um, a second offense is a positive test. A second positive test offense is a dischargeable offense, meaning you could be fired. Um, Five other dischargeable offenses: failure to successfully complete rehabilitation, a positive assessment as part of or aftercare drug testing, and failure to comply with an aftercare treatment plan, and an adulterated or substance specimen. Um, Section 35, Article 14, preparation for testing. Um, Pursuant to Department of Transportation regulations, the employer reserves the right to utilize on-site or off-site collection facilities. Upon arrival at the collection site, an employee must provide the collection agent with the photo identification issued by the employer or federal, state, or local government. Um, if the employer arrives, if the employee arrives without the above listed items, the collection agent should contact the district safety and health manager, or district human resources manager. Um, A standard approved urine custody test and control form shall be supplied by the appropriate laboratory, and this form must be used by all collection facilities and it has to be signed by the employee and the collection agent in the appropriate area. Um, Section 35, Article 15, specimen collection procedures. Yeah, there's a lot of shit when it comes to drug testing. Um, the employee or employer agrees to continue the use of the specimen collection checklist. The current checklist is to be used with the affected employee at the collection site by the person performing the collection services for the employer. Um, the checklist is to be used at all locations, but it is understood that failure to use or the refusal to use the checklist does not invalidate a properly conducted controlled substance testing procedure, nor does it prohibit an employee's recourse in the collective bargaining agreement and or the agreement's procedure. Um, all procedures for urine collection shall follow Department of Transportation guidelines to ensure an individual's privacy. An employee also gives reason to believe that they have adulterated or substituted a sample shall be required to provide a specimen under direct observation by a same gender or collection agent if it is determined that an employee has an adulterated or substituted sample. It shall result in the termination of their employment. Um, Now, no unauthorized personnel shall be allowed in any of the area collection site. Only one controlled substance testing collection procedure shall be conducted at a time, and the specimens can only be handled by the collection site person. Um, Now, the employee being tested should remove any outer garments such as coats, jackets, hats, or scarves, and they should leave any personal belongings like a purse or briefcase with the collection agent. The employee shall display the items in their pockets to the collection agent. If the employee requests it, the collection agent shall provide the employee receipts for his or her belongings. The employee may retain his or her wallet. But after washing their hands, the employee shall remain in the presence of the collection agent, and they should not have access to any water fountains, faucet, soap dispenser, cleaning agent, or other materials which could be used to adulterate the substance or the specimen. The collection agent provides the employee with a new sealed kit that's selected by the employee. Now, the employee shall provide his or her specimen in a stall or otherwise partitioned area that allows for them to have privacy. Now, the employer agrees to recognize all employees' rights to privacy while being subjected to the collection process at all times at all collection sites. Now, further, the employee agrees that in all circumstances the employee's dignity shall be considered and all necessary steps should be taken to ensure that the entire process does nothing to demean, embarrass, or offend the employees unnecessarily. Now, yeah, because I would not want to be embarrassed if I'm ever at work. Even though people embarrass me all the time, a lot of them do. Authorization for collection under the direct observation shall be in accordance with the Department of Transportation regulation. All procedures shall be conducted in a professional, discreet, and objective manner. Refusal to provide a specimen under direct observation when requested shall be considered a refusal to test and a terminable offense, meaning being fired. The employer shall be instructed to provide at least 45 millimeters of urine in the collection container. Now, the employee shall hand the specimen to the collection agent, and the specimen shall remain in the sight of both the collection agent and the employee at all times. A minimum of 30 millimeters of urine shall be placed in the primary specimen container um, by the collection agent. Now, the collection agent then must pour at least 15 milliliters of urine from the collection container into the second specimen bottle to be used for the split specimen. Now, if for whatever reason the individual is unable to provide 45 millimeters of urine, the collection agent shall direct the individual to drink fluids and not to exceed 40 ounces distributed reasonably over a period to accept 3 hours or until a sufficient specimen is provided. Whichever occurs first, the original specimen, if any, should be discarded unless it was out of temperature range or showed evidence of adulteration or tampering. Now, if the individual is still unable to provide 45 milliliters of urine, they should be taken out of service, and a medical evaluation should be conducted within 5 business days by a licensed physician who has the expertise in this type of medical issue, and it is approved by the employer to determine if there is a medical reason for the inability to provide a specimen. If it is not determined that there is a medical reason, the individual shall be treated as having refused to take the test. Now, if the employee fails for any reason to provide 45 millimeters of urine, the collection agent should contact a third-party administrator, also known as a TPA, and either the district safety and health manager or another employee designator. Now, the regulations specify that the privacy procedures and the reason to believe that a specimen has been adulterated, which includes but is not limited to and to conduct a clearly and unequivocally indicating an attempt to substitute or adulterate the sample, abnormal urine color or urine temperature outside the acceptable range. All specimens suspected of being adulterated should be packed and forwarded to the laboratory for testing. Um, like I said, they got a big ass breakdown on this drug testing shit. Most of the stuff in the book is taken. Most of the stuff in the Union book is taken up by drug testing stuff. Um, in the event of the suspected specimen adulteration, a second specimen shall be immediately collected under direct observation, and the entire procedure should be repeated, including initiation of a new custody and control form and separate packaging for shipping. If an employee refuses to provide a second specimen, it shall be noted as a refusal to test and shall be a terminable offense. The collection agent shall document any unusual behavior or appearance on the urine custody and control form. Specimen handling from one authorized individual or place to another shall always be conducted using chain of custody procedures. Every effort must be made to minimize the number of people handling specimens. Both specimen containers should be sealed and then forwarded to an approved laboratory for testing. When a return to duty or follow-up test is being conducted, the collection process may be observed, and if observed, the observer shall be the same gender as the employee being tested. Now, when a test kit is received by a laboratory, the 30 millimeter sealed urine specimen container shall be removed immediately for testing. The shipping container within the remaining sealed container shall be immediately placed in the secure refrigerated storage. Now, if an employee is told that the first sample tested positive, the employee may, within 72 hours of receipt of actual notice, can request that the second urine specimen be forwarded by the first laboratory to another independent and unrelated HS approved laboratory of the party's choice for GC and MS confirmatory testing of the presence of the drug. Now, if an employee chooses to have the second sample analyzed, they shall at that time execute a special checkoff authorization form to ensure payment by the employee. Now, if the second test is positive and the employee wishes to use the rehabilitation option, the employee shall reimburse the employer for the cost of the second confirmation test and handling and shipping charges before entering the rehabilitation program. For those employees who choose to have the second specimen tested, disciplinary action can only take place after the MRO verifies the first test as positive for first laboratory reports a positive finding and the second laboratory confirms the presence of the drug. Now, however, the employee must be taken out of service once the second test is being performed. Now, if the second laboratory report is negative, um, the employee shall not be charged for the cost of the second test and shall be reimbursed for all lost time. But it's understood that if an employee opts for the second testament to be tested, the contractual timeline limits on disciplinary action in this agreement are going to be waived. Are going to be waived in that case. Section 35, Article 16, specimen shipping preparations. After measuring temperature and visibly inspecting the urine specimen, the collection agent should tighten and seal the specimen shipping container. Now, the collection agent places a security label initialed and dotted by the employee, and also dated, over the bottle cap overlapping the bottle sides. A double pouch bag shall be used for shipping, within one side for the urine specimen and the other for any paperwork. The collection agent places the urine specimen in the sealable pocket of the specimen bag, and then it seals the bag. The collection agent places the urine specimen in the sealable pocket of the specimen bag, and then they seal off the bag. The collection agent places laboratory copies of the urine custody and control form in the back sleeve of the double pouch bag. Now the employee receives a copy of the urine custody and control form. Section 35, Article 17, District Medical Review Officer. Any person serving as a medical review officer for the company must be a licensed doctor of medicine or osteopathy with knowledge of substance abuse disorders, issues relating to adulterated and substituted specimens, possible medical causes of specimens having an invalid result, and an applicable DOT agency regulation. In addition, the MRO shall keep current on applicable DOT agency regulations and comply with the DOT codifications, training, and continuing education requirements. Now, the MRO is responsible for performing the following functions in addition to those specified in the DOT regulation. Reviewing the results of UPS's drug testing program, receiving all positive and negative drug test reports as prescribed under the DOT regulations, and making all reports of drug test results to the employer. Within a reasonable time, notifying the employee of a confirmed positive test result, reviewing and interpreting each confirmed positive test result in order to determine if there is an alternative medical explanation for the specimens testing positive. The MRO shall perform the following functions as part of the review of a confirmed positive test result, and they provide an opportunity for the employee to discuss a positive test result. They provide an opportunity for the employee to discuss a positive test result. They review the employee's medical history and relevant biomedical factor. A driver is allowed to use a controlled substance except for meth only when taken as prescribed by a licensed medical practitioner who is familiar with the driver's medical history and assigned duties. Now, they review all medical records made available by the employee to determine if a confirmed positive test resulted from legally prescribed medication or other possible explanation. They verify that the laboratory report and assessment are correct. The MRO shall be authorized to request that the original specimen be reanalyzed to determine the accuracy of the reported test results. Now, processing an employee's request to test a split sample, such testing shall be conducted at the employee's expense. The employee shall be reimbursed by UPS for any such expense should the retest provide a negative result. If a reanalysis is negative, then the MRO should declare the test canceled. MRO determination for Section 35, Article 18. If the MRO determines after appropriate review that there is a legitimate medical explanation for the confirmed positive test result, the MRO shall report the test to the employer as a negative. Now, if the MRO determines that after appropriate review that there is no legitimate medical explanation for the confirmed positive test result, the MRO shall report the positive test result to the appropriate member of management in accordance with DOT regulations. Based on the review of laboratory reports, the quality assurance and quality control data and other drug test results, the MRO may conclude that a particular confirmed positive drug test result shall be canceled under these circumstances. The MRO shall that the test is canceled. Now, based on a review of laboratory Oh, sorry, I already did that one. No, not later than 72 hours. Not later than 72 hours after count of notification of a confirmed positive test result, or refusal to test because of adulteration or substitution. An employee may submit a written or verbal request to the MRO for testing of the split sample. The laboratory used must be certified by the HHS and must follow usual chain of custody procedures. Now the employee shall be reimbursed for any pay loss if taken out of service based upon a positive test result, which is negated by the second test, or as the result of the resolution of the grievance. Um, um, Section 35, Article 19, Record Retention. The medical review officer is the sole custodian of the individual test results. The MRO shall retain reports of individual positive test results for a minimum of 5 years. Individual negative test results shall be maintained for at least 12 months, and UPS shall maintain in the driver's qualification file only as such information as required by the to document compliance with the drug testing requirements. Um, Section 35, Article 20, release of drug testing information. Um, the MRO shall inform the employee before beginning the verification interview that the MRO should transmit to appropriate parties the information concerning medications being used by the employee, um, or the employee's medical condition only if the MRO's medical judgment. The information indicated that the employee may be medically unqualified under applicable agency rules. Um, Now, when a grievance is filed as a result of positive test, the employer shall obtain from the laboratory its records relating to the drug test. Upon receiving the records, the employer shall provide copies to the appropriate official of the union by the end of the following business day after receiving the documents from the laboratory or the MRO, as assigned. Um, um, okay, yeah. Um, Now, now you can always file agreements. You can file agreements for many different reasons. You can file agreements for being sent home early. The thing is if you're a UPS employee and you work part time, you can file agreements because you're guaranteed 5 hours. If you're not, if they clock you out before your 5 hour mark, you can file agreements. If you're a part time employee, they've done that to me numerous times already. Next time they do it, I'm going to file agreements. If I don't get my 5 hours, then I'm guaranteed. Um, Now, when a grievance is filed, as I was saying, as a result of a positive test, the employer shall obtain from the laboratory its records relating to the drug test. Upon receiving the records, the employer shall provide copies to the appropriate official of the union by the end of the following business day after receiving the documents from the laboratory or the MRO as applicable, provided that the employee has executed written consent authorizing a release to the union, a copy of which must be provided to the employer. The company agrees to notify the union of any change of HHS approved laboratories used for drug testing for whatever reason. Um, Article 35, Section 21, paid for time. Testing except for drug tests taken in conjunction with a dot physical, the employee shall be paid at the regular straight time hourly rate of pay in the following manner. Um, for all time at the collection site, if the collection site is reasonably en route between the employee's home and the center, and the employee is going to or from work, pay for travel time one way between the center and the collection site, or the collection site to the center, or for travel time both ways between the center and the collection site, only if the collection site is not reasonably en route between the employee's home and the employee's center. If an employee is called at home to take a random drug test at a time when the driver is not en route to or from work, the employee shall be paid in addition to all time at the collection site, traveling time both ways between the employee's home and the collection site with no minimum guarantee. Now, when an employee is on the clock and a random drug test is taken anytime during the employee's shift and the shift ends, um, After 8 hours, the employee shall be paid time and a half for all time past 8 hours if you're working 8 hours, if you're full time, that is. Um, the parties have agreed that the procedures as set forth in Article 35, Section 35.4 shall be the methodology for testing and shall be modified and only in the event that further federal legislation of the Department of Transportation regulations required by regulation revised testing methodologies and requirements during the term of this agreement. Where such negotiations allow revised testing methodologies, such modifications shall be subject to mutual agreement by the parties. Um, Section 35, um, Article 4.1, employees who must be tested for drugs. The UPS employees subject to Department of Transportation mandated alcohol testing are drivers of vehicles with a vehicle weighing over 26,000 pounds, and they require a commercial driver's license, also known as a CDL. This concludes mechanics and employees who relieve for vacation or temporary vacancies. Any employee who drives a tractor trailer and is on the qualified feeder driver list is also subjected to the DOT mandated testing as provided in this agreement. Um, Section 35, Article 4.2, testing. Because of the consequences that a positive test result has on an employee, UPS shall employ a very accurate two-stage testing program. The breath samples shall be collected by breath alcohol technician, also known as BAT, and who has been trained in the use of the evidential breath testing, also known as the EBT device, and a course equivalent to the DOT's model course. All samples should be tested according to DOT alcohol testing requirements. In the event that breath testing is not possible, in such cases as reasonable cause or post-accident, the employer has the right to use alternative DOT approved methods. Section 35, Article 4.3, screen testing. The initial screening test uses an evidential breath testing, also known as an EBT, device to determine the levels of alcohol. The following initial cutoff levels should be used when screening specimens to determine whether they are negative for alcohol. The EBT device must also be capable of distinguishing alcohol from acetone, or at the 0.02 concentration level, and test an air blank, and they have to perform an external calibration check. Breath alcohol levels less than 0.2. If your alcohol level is 0.2 or lower, then it's negative. Anything higher than the 0.8 is positive, and it requires a confirmation test. Section 35, Article 4.4, confirmatory testing. All specimens identified as positive on the initial screening test showing an alcohol concentration of 0.2 or higher shall be confirmed using an EBT that is capable of providing a printed result in a triplicate, and it is capable of assigning a unique and sequential number to each test, and it's capable of printing out on each copy of the printed test result the manufacturer's name for the device's serial number, and the time that the test was taken. A confirmation test must be performed not sooner than 15 minutes after the screening test, but not only more than 30 minutes before the confirmatory testing and screen testing. Basically, the following cutoff levels should be used to confirm the presence of alcohol. If you're less than 0.2, it's negative. Anything higher than 0.2, positive and out of service for 24 hours from time of the test. Anything higher than a 4, 0.04 and above, positive and out of service, and you have to be referred to a substance abuse professional, also known as an SAP. Section 35, Article 4.5, types of testing required. The testing procedure shall be performed as part of a pre-qualified practice after the defined reportable accidents on the basis of reasonable cause upon return to duty after a positive test, and under DOT mandated random testing, and as follow-up testing for post-alcohol rehabilitation as outlined under Article 16, which we had talked about that one before. Also tax season is above us. We're going to be getting our tax forms. Um, I have never done my taxes by myself before, so this will be the first time. The last several years, my mom used to do them for me because I was working 2 and 3 jobs and I was never home, so I never had time to do my own taxes, and my mom always did it for me, so I wouldn't get behind. So now this will be the first year since my mom's death. My mom died in October of last year. This will be the first time where I got to do my taxes on my own, and I've never done it. Um, so I gotta look and see how to do them. Um, but you should get all your tax forms by the 31st of this month. I think I got my UPS one. Now I'm waiting on two. Now I'm waiting on 3 others from last year. From last year to be delivered this year, and I don't have them yet. So I have to go with that one. Um, oh, Now, upon reasonable cause, the UPS shall require an employee to be tested for the use of alcohol. Um, Reasonable cause is defined as an employee's observable action, appearance, or conduct that clearly indicates the need for a fitness for duty medical evaluation. Now, the employee's conduct must be witnessed by at least 2 supervisors if available. The witness must have received training in observing a person's behavior to determine if a medical evaluation is required. Now, when the supervisor confronts an employee, a union representative should be made available pursuant to Article 4 of this agreement. If no union steward is present, the employee may select another hourly paid employee to represent them. Um, Now, documentation of the employee's conduct shall be prepared and signed by the witness within 24 hours of the observed behavior. In addition, a copy shall be sent to the union in a timely manner. Non-DOT reasonable cause testing. Employees covered by this collective bargaining agreement and who are not subjected to DOT mandated alcohol testing are only subject to reasonable cause testing as provided in accordance with supplemental practices. Um, oh shit, hold on here. Let me see when the next articles thing is coming up. Um, because I'm on page 112 right now. Like I said, Article 35, which talks about alcohol and drug testing, takes up most of the book. Um, it goes from page 90 to 121. Okay. So I got 9 more pages of that to read. For that portion. Um, Section 35, Article 4.7. Post-accident alcohol testing. DOT mandated drivers shall be required to submit to an alcohol test after a DOT defined serious accident, which is one in which there is a fatality or citation is issued and there is bodily injury to a person who, as a result of the injury, receives immediate medical treatment away from the scene of the accident, or a citation is issued and one or more motor vehicles incur disabling damage as a result of the accident, requiring vehicles to be transported away from the scene by a tow truck or any other vehicle. Um, um, the non-DOT mandated drivers may be required to submit to alcohol testing if there is any reasonable suspicion of alcohol usage or reasonable cause to believe that a driver has been operating a vehicle while under the influence of alcohol, or reasonable cause is to believe that the driver was at fault in the accident and alcohol usage may have been a factor. Alcohol testing should be required after accidents. Yeah, it's good to see people tuning in. It's been a while since I haven't done a live stream for a while, but now I'm getting back into them. I try to do one at least every week. I also have another YouTube channel called RVW King. Anybody interested in checking that out, you can. Um, um, now, Now, the reasonable cause to believe that the driver was at fault in the accident and alcohol usage may have been a factor. Alcohol testing should be required after accidents under the above conditions, and drivers are required to submit to such testing within 2 hours of the accident. Now, if possible, yes, I can. But give me a minute here. I am in a new place. I'm living with roommates. I'm living in Chicago. I'm living in Willow Springs, Illinois, which is a suburb of Chicago. Um, it's actually kind of quiet out here. There's not a whole lot to do out in this area, but there is a coffee house. You got a restaurant, a couple places where you can get jobs at, but not a whole lot of big stuff out here. Um, Drivers are required to submit to drug testing as soon as possible within a 2-hour frame. Under no circumstances shall the type of testing be conducted more than 8 hours after the time of the accident. Um, it shall be the responsibility of the driver to remain readily available for testing after the occurrences of a commercial motor vehicle accident. It is also the responsibility of the driver to not use alcohol for 8 hours or until an alcohol test is performed under the section, whichever occurs first. Union representation shall be made available pursuant to Article 4 of the agreement. It is not the intention of this language to prohibit the driver from leaving the scene of an accident for the period of time necessary to obtain assistance in responding to the accident or to receive necessary medical attention. And this is all in the union handbook for UPS, or just any job that has a union. They have all the stuff in there. Um, um, Now, law enforcement testing. The result of a breath or blood test for the use of alcohol or or a urine test for the use of controlled substances conducted by federal law, federal, state, or local officials having an independent authority for the test shall be considered to meet the requirements of post-accident testing, provided such tests conform to applicable federal, state, or local requirements, and that the results of the test are obtained by the employer. Section 35, Article 4.8, Random Drug Testing and Random Employee Selection. The procedure used to randomly select employees for alcohol testing in compliance with the U.S. Department of Transportation regulations shall be a computer program specifically intended for such a use. Now, the program shall utilize an internal computer clock procedure to randomly generate list of employees mandated for testing by the Department of Transportation, Federal Highway Administration. The computer shall randomly select the required number of employees from the total pool of affected employees. The total pool list shall be by each region. The pool of employees selected randomly for controlled substance testing shall also be the pool of employees selected for alcohol testing in compliance with DOT regulations. Now, for verification purposes and to cover absences, the computer shall print the following list for each testing period. Now, an alphabetical total pool list of employees in the region, a district list of employees shall be printed from the random list in the order to which they are computer selected. An absent employee whose name appears on the random test list must be tested upon return to work immediately after notification, provided that they return before the next selection period. The list or true copies of the list shall be maintained by a third-party administrator. Upon request to the District Labor Relations Manager, the list shall be made available for review by union representatives and company labor relations manager to verify the proper application and use of the list in the random testing system. The parties agree that no effort shall be made to cause the system and method of selection to be anything but a true random selection procedure, and ensuring that all affected employees are treated fairly and equally. The parties further agreed not to amend or change the current method of random selection as described herein without prior agreement between the parties. A driver shall only be tested for alcohol while the driver is performing safety and sensitive functions, just before the driver is to perform safety sensitive functions, or just after the driver has ceased performing such functions. Employees who are on long-term illness or leave of absence should not be subjected to testing. Section 35, Article 4.9, notification. UPS employees subject to the Department of Transportation mandated random alcohol testing shall be notified of testing and pursuing in a person or by direct phone contact. Notification shall be given by the management person responsible for such notification. Now, Section 35, Article 4.10, rehabilitation and testing after return to duty. If the breath alcohol technician, also known as the BAT, determines the specimen is a confirmed positive, then the employee shall be removed from service and have 5 calendar days to evaluate their situation with an approved substance abuse professional, also known as an SAP, and then they have to have up to 15 calendar days to enter the rehabilitation treatment center after approval of a leave of absence as outlined in the Article 16, Section 5 of this agreement. UPS shall follow the final recommendations of the Substance Abuse Professional (SAP) concerning the appropriate aftercare protocol and post-rehabilitation unannounced alcohol testing. It's understood that if the grievance procedure is utilized, contractual time limits on disciplinary action and the employee's request for rehabilitation shall be suspended until resolution of the grievance. Now, the provision of Article 16, Section 5 shall apply to all employees requesting enrollment in a rehabilitation program following a positive alcohol test. Now, employees may use the United Postal Service Employee Assistance Program, a union-sponsored program, as well as any other referral service in choosing an approved program for treatment. Now, if you're tuning in, make sure to hit that like and subscribe button. If you're coming in and chatting, also leave a comment. Let me know what you guys are thinking. And also have a Patreon link if you're interested. You can donate to that to help out the cause for the channel. Follow-up testing shall consist of at least 6 tests to the first 12 months of following the driver's return to duty, but the 1 year period may be extended as necessary by written verification of the SAP. The employer responsibilities. Now, prior to allowing an employee to return to duty after the employee has tested positive for an alcohol concentration higher than 0.2, or actually higher than 0.02, or they have refused to submit to alcohol test, the employer shall ensure the employee is alcohol free, defined in less than the 0.2 than the 0.02 based on the alcohol test. Ensure that the employee has been evaluated by an SAP for alcohol use or abuse. Ensure and confirm with the SAP that the employee demonstrates compliance with all the conditions or requirements of a rehabilitation program in which they participated in. Section 35, Article 411, Discipline. It is agreed that an employee shall have a rehabilitation opportunity for alcohol abuse as outlined in Article 16, Section 5, except as provided under the random testing below, and there shall also be a one-time rehabilitation opportunity for the substance abuse. Number one, reasonable cause testing, because they do have reasonable cause to test people. An employee who has tested for a reasonable cause and whose alcohol level is higher than 0.2 shall be taken out of service for 24 hours and receive a warning letter. An employee who was tested for reasonable cause and whose alcohol level is 0.04 to 0.6 shall be taken out of service for 24 hours, and they have to be referred to a substance abuse professional and suspended for up to 10 days. If the employee has committed a disciplinary offense under the terms of this agreement, the results of the test may be used in the support of the employer's disciplinary action. A second positive test of a 0.2 or above is a dischargeable offense. A positive test of 0.7 or above is a dischargeable offense. A presumption exists that the employee was drinking on the job if the observation, time of testing, and alcohol level combined to show the employee's level was too high to have consumed alcohol prior to the employee's report time. An employee taken out of the service for a positive test result must have a negative test prior to returning to work. Post-accident testing. An employee who is involved in an accident for which the mandate requires post-accident testing must submit to such a test. A post-accident test of 0.2 or above is a dischargeable offense. Random testing. A positive test of 0.2 to 0.03 shall result in the employees being taken out of service for 24 hours and a warning letter shall be issued. A second positive test of 0.2 to 0.6 or an additional positive test of 0.4 or above shall result in the employee being taken out of the service and have a 10-day suspension shall be imposed. Now, the employee shall also be referred to a substance abuse professional for evaluation. Now, if the SAP requires an inpatient treatment and that an inpatient treatment in the second such treatment afforded to the employee, the cost of such treatment shall not be borne by the UPS medical plan. A third positive test of 0.02 or above, after the employee was tested pursuant to the above levels, the employee shall be subject to being fired. Dischargeable offenses, other language to the contrary notwithstanding, the following result and discipline up to and including the discharge: failure to successfully complete rehabilitation, a positive test defined as 0.02 or higher as part of a post care testing, and failure to comply with all the aftercare treatment plans. Um, possession of possession of and or consumption of an alcoholic beverage while on duty. Any test of an on-duty employee that measures at or above the state mandated DWI testing, should any state reduce the DWI mandated levels of below the 0.8, the employer and the union agree to meet and renegotiate Section E of this agreement. An employee's refusal to submit to a negotiated test and non-mandated employees shall be subject to reasonable cause testing as outlined above. And no circumstances under this section shall suspension time run concurrently with any level period, or with any leave period, basically. Section 35, Article 4.12, preparation for testing. Pursuant to Department of Transportation regulations, the employer reserves the right to utilize on-site or off-site testing facilities. Under no circumstances shall the employer utilize EPS personnel to serve as a breath alcohol technician, also known as a BAT. Upon arrival at the testing site, an employee must provide the BAT with photo identification. Now, if the employee arrives without the photo identification issued by the employer, or a federal, state, or local government, the BAT should conduct the district safety and health manager or the district human resources manager. A standard DOT approved alcohol testing form must be used by testing facilities. The form used for the non-DOT test should contain the same concentration or the same information as the DOT form. Um, Section 35, Article 4.13, specimen testing procedures. Now, the employer agrees to implement a specimen testing checklist. Now, the current checklist is to be used with the affected employees at the testing site by the person performing the test for the employee. The checklist is to be used at all locations, but it's understood that failure to use or the refusal to use the checklist does not invalidate a properly conducted alcohol testing procedure, nor does it prohibit an employee's recourse to the collective bargaining agreement and other grievance procedures. Procedures for alcohol testing shall follow Department of Transportation guidelines to ensure an individual's privacy. Um, no unauthorized personnel shall be allowed in any of the area of the testing site. Only one alcohol testing procedure shall be conducted at a time. Um, Now, the employee shall provide their specimen in a location that allows for privacy, which I agree with because you should always have your privacy when you're pissing and shitting. Um, Now, the employer agrees to recognize all employees' rights to privacy while being subjected to the testing process at all times and at all testing sites. Now, further, the employee agrees that in all circumstances the employee's dignity shall be considered and all necessary steps shall be taken to ensure that the entire process does nothing to demean, embarrass, and offend the employees unnecessarily. Testing shall be under the direct observation of a BAT. All procedures shall be conducted in a professional, discreet, and objective manner. Direct observation shall be necessary in all cases. Um, the employee shall provide an adequate amount of breath for the EBT device. If the individual is unable to provide a sufficient amount of breath, the BAT shall direct the individual to again attempt to provide a complete sample. If the employees fail for any reason to provide the requisite amount of breath, the BAT shall conduct the district safety and health manager or human resources manager. If an employee is unsuccessful in providing the requisite amount of breath, the employer then must have the employee obtain within 5 business days an evaluation from a licensed physician chosen by the employer who has the expertise in the medical issues concerning the employee's medical ability to provide an adequate amount of breath. Now, if the physician determines that a medical condition has or with a high degree of probability could have precluded that the employee from providing an adequate amount of breath, the employee's failure to provide an adequate amount of breath should not be deemed a refusal to take the test. Now, if the physician is unable to make a determination that the employee was medically unable to provide a sufficient amount of breath, the employee shall be regarded as refusing to take the test. Now, The bat shall document any unusual behavioral appearances on the alcohol testing form. Section 35, Article 4.14, Substance Abuse Professional, also known as the SAP. Each substance abuse professional (SAP) must be a licensed doctor of medicine or osteopathy, or a licensed or certified psychologist, social worker, employee assistance professional, or drug and alcohol counselor, certified by the National Association of Alcohol and Drug Abuse Counselor Certification Commission, with knowledge of clinical and experience in the diagnosis and treatment of alcohol and controlled substance-related disorders, and be knowledgeable of the SAP function as it relates to employee interest in the safety-sensitive function and applicable agency regulations. Um, in addition, the SAP shall keep current um, um, on applicable agency regulations and comply with the regulation training and continuing education requirement. Now, the SAP is responsible for performing the following functions. 1. Conducting the initial face-to-face clinical assessment and evaluation to determine what assistance is needed by the employee to solve problems associated with their alcohol and or drug use. 2. Referring the employee to an appropriate educational and or treatment program. 3. Conducting a face-to-face follow-up evaluation to determine if the employee has actively participated in the education or treatment program and has demonstrated successful compliance with the initial assessment and evaluation recommendations. 4. Providing the employer with a follow-up drug and alcohol testing plan for the employee. 5. Providing the employee and employer with the recommendations for continuing education or treatment. Section 35, Article 4.15, record retention. The employer shall maintain records in a secure manner so that disclosure of information to unauthorized persons does not occur. Each employer or its agent is required to maintain the following records for up to 2 years. 1. Records of the inspection and maintenance of each EBT used in employee testing. 2. Documentation of the employer's compliance with the quality assurance, also known as the QAP, for each EBT, its uses for alcohol testing. 3. Records of the training and proficiency testing of each batch used in employee testing, and any required logbooks. The employer or its agent must maintain for up to 5 years pertaining to the calibration of each EBT used in alcohol testing, include records of the test results of external calibration checks. Section 35, Article 4.16, Release of alcohol testing information. Now, the breath alcohol test technician, known as the BAT, shall inform the employee before testing that the employer shall be notified if the confirmatory test is greater than 0.2, since the employee shall be removed from service and considered medically unqualified to drive under the agency rules and regulations. When a grievance is filed as a result of a positive test, the employer shall obtain records relating to the alcohol test upon receiving the records. The employer shall provide copies to the appropriate official of the union, and by the end of the following business day after receiving the documents from the laboratory or the MRO, as applicable, provided that the employee has executed written consent authorizing release to the union, a copy of which must be provided to the employer. Section 35, Article 4.17, paid for time. Testing. The employee shall be paid for the regular straight time hourly rate of pay in the following manner: for all time at the testing site. 2. If the testing site is reasonably en route between the employee's home and the center, and the employee is going to or from work. Now pay for travel time one way between the center and the testing site, or the testing site to the center, or for travel time both ways between the center and the testing site, only if the testing site is not reasonably en route between the employee's home and the employee's center where they work at. Now, when the employee is on the clock and a random alcohol test is taken during any time during the employee shift, and the shift ends after 8 hours, the employee shall be paid time and a half for all time spent past the 8-hour mark. Okay, that is the end of Article 35. Next week we'll pick up at 36. If you want to see a house tour, let me get up and do that. Most of the time it's just me and one other guy here, because UPS is currently my only job that I get paid for. And because I only work from like 3 to 9 or 4 to 9 in the morning, I'm home the rest of the day doing nothing much else. Um, this is my room. It's a lot bigger than my last room that I had in my old apartment. That is our swimming pool. It's not up and running yet because because it's winter time, so we do have a swimming pool. And it's kind of deep there. I put my movies all over here, so I use it. I use this as a little storage area for all my movies. So that is all my movies right there, along with right here. Um, I got laundry day to do today. That's why my clothes are on the floor. I gotta sort out what's dirty and what's clean. This is my closet to my room. It's not a big one, but it's pretty. But it's still a decent size. It's nothing compared to the other one. And then I don't know what the hell this is up here, but you can put storage underneath here. There's like a little section for storage on both sides. Then you got this right here, extra storage. You got a key to my own room. This is my own bathroom. We leave the water running for pipes so they don't freeze. We had a pipe burst in the house last week, and we had to get the whole ceiling in the kitchen gutted. So we're gonna get a new ceiling in the kitchen. This is my shower. Kind of small, but it works. Then you got this right here, so if you ever come in to take a shower, you can put your clothes on here, stuff like that. You got a closet right here for any extra storage if you ever need it. There's a couple of these around the house. There's a toilet. Is that a toilet brush in there? Yeah, that might be a toilet brush in there. Now this room I'm not supposed to go in, but I don't care. I'm gonna go in. I don't think anybody's here. Yeah. Nobody's here in this room. But this is the one room I like. This is the master bedroom. It's the biggest room in the house. You can see how big this is. Technically I'm not supposed to be in this room. This room actually belongs to somebody, but the guy's moving out. But I would love this room just for the bathroom alone. He's got a closet there. That's a small one to put like your jackets, whatever you want to put there. I do like that recliner chair. If I ever do get this room, I would love to put my computer there, and just set it up there. This is the bigger closet, but you gotta be careful with the door because it sticks and it's broken. So you got your closet right here. And then you got stuff to put on the floor. It's a pretty decent size. And then you got another closet right here. This is another closet, a fridge. All that stuff was left here. This is the hot tub. Nobody ever really uses it. So you got your hot tub here. You got your two sinks right here for like husband, wife, his, hers thing. And then you got another shower right here. A sit-down one where you can sit down on either side. This room is actually to die for if you ever have it. So this is one room I would love to have if I had the money to cover it. Oh yeah, I'll turn my light off here because I don't need it on. This door right here leads to above the garage. The owner of the house wants to turn that into like an extra balcony where you can sit on top of the garage. I don't know if anybody wants to do that, but that's what he wants to do. We got a couple bedrooms down here. Since people live in them, we cannot go in them unless we have permission. So I'm not gonna bother going into their shit. One bedroom belongs to a guy named John. The other one belongs to a guy named Madame. So I don't go in their rooms because they live there. We have a little office right here that nobody really bothers to use, but it's a little office space if you ever want to like just sit there and look up stuff. Um, we had to move the refrigerators over here because when the pipe burst in the kitchen, we had to move everything out the way so that they could gut the ceiling, which you're going to see in a minute when the pipe burst. You got another bathroom here. This is the other bathroom for the people that live on this floor. Now you can see how the ceiling got gutted because when the pipe burst, it was like right in this area right here where they just poured down water. Then you got so with the swimming pool, you got your diving board across the way. You got like your little seat right over there along with the little fire pit and the barbecue thing. Then you got your little balcony right here. During the summertime, you could sit on the balcony and read if you ever decide to. We have the fridge right here. This is all my stuff. I just stocked up on all my food today because I was running low on food. So this is all the stuff that I got today, along with whatever's in here, in the 2 drawers down here. That and this, and all my drinks, like my Pepsi and my root beer buried in there. You can see my root beer on the floor. Now, we got one more floor to go to, but I can't show you everything, at least not that. This door is to the garage. This one right here is to the garage. If you open it, you'll see the garage. Yep. And we've just been using it as storage. That door back there goes to the back porch. Never really been back here. This guy has the whole house decked up with I drew up this little deer. One of the guys is talking to down here, so I gotta be careful. This is one of the bedrooms. That's the owner's room. He's got his own bathroom in there. And there's another bathroom here. 2 more closets. And then you got your laundry room with your shower and with your washer and dryer. And then you got your little mop sink, swap sink thing where you could just do stuff like that. And that's really it. We did have an extra like you know how you have this right here? We had another one of these over here, but it got ruined, so we had to take it out. That sucks. And that's really it. And you have your little picture line right here and right there. I love that. I think the guy that stays home mostly is here. He just got back. Okay, that is it from the live stream of the house tour. If it wasn't for the fact that so many people live here, I would get more stuff in there. So I hope you guys enjoyed the live stream video and the live stream for not just the union handbook, but the house. Like I said, it's a decent sized looking house. It's a lot bigger than where I was staying at before. The last place I was living at was a 2-bedroom, 1 bath, but the place was a dump and the landlord didn't fix anything. So now I'm in a better place, closer to my job. I have a second job interview on Monday for a second job because, you know, one job out here in Illinois isn't going to cut it if you're not getting hours. I'm not going to tell you what the job is yet unless I get it. And if I do, I'll let you guys know. Um, but how was everybody doing on this wonderful Saturday? Um, so but if you like the video, you can give the video a like and subscribe. Make sure to smash that like and subscribe button for more videos like this, because sometimes people love videos like this. Make sure to leave a comment. Let me know what you guys are thinking. Depending on whatever it is, any questions that you have, feel free to post them in the live stream, or any random videos that I do. Um, we'll be back next week to pick up at the article 36. So it'll probably be next Saturday when I get my video up for that one. So make sure to smash the like and subscribe button for more videos like this. Leave your comment. Let me know what you guys are thinking. And if you want to support my work further, donate to the Patreon link, which you're going to find in the about section of YouTube. And for just as little as a few bucks a video or a month, your donation can help go a long way. And thanks for listening, guys.